Good morning to everybody on this session. So I'm going to cover maintaining high professional standards this morning. We're down for about 2 hours, which will leave plenty of time, hopefully, for questions and answers as well. And we find for these sessions, particularly on MHPS, that the people often have quite a few questions. So I'll come on to what we're going to cover, what I'm going to cover in a moment, but just very briefly by way of introduction. My name is Andrew Davidson. I'm the National Head of Employment at Hempsons. I work dominantly, in fact, almost entirely with NHS trusts and foundation trusts, and I've been working with NHS organisations, particularly in relation to MHPS, for almost 20 years. MHPS has been out for almost 20 years, and I've been working with NHS organisations in that time on MHPS matters. The reason I say that is because most of the kind of situations that organisations find themselves in, I've probably come across in the course of those almost 20 years. So I'm going to cover a number of things in this morning's session. I'm going to cover a little bit of a background to MHPS, the origin of MHPS, just to give some context. Then I'm going to look at parts of the framework, and that's going to be the bulk of the session, looking at practical issues around the implementation of MHPS and how it works. Briefly, a few words on third-party involvement and how to manage those issues, such as criminal involvement and so on. And then at the end, I've just picked a very small handful of cases which illustrate different points arising from MHPS. So just looking at the background then, and the background I think is important because there's a lot of mystique around MHPS and people think it's very complicated and complex, and it is in places, that's for sure. But it's helpful to have a little bit of a background to MHPS so you understand sometimes why things are the way they are. So the framework itself is a national framework. It was introduced in February 2005. Well, it was implemented in a series of phases, but it was finally implemented in February 2005. And it replaced some provisions, which I'm not going to talk about in detail, but it replaced some provisions dealing with doctors' disciplinary and capability issues, which are extraordinarily legalistic and formal. And so if you find yourself thinking MHPS is legalistic and formal, well, actually, it was intended at the time to be a very user-friendly version of a framework which had previously been very difficult to understand and implement. And so it's worth bearing in mind this was intended. It may not always meet the mark, but it was intended to be a relatively user-friendly framework. NHS trusts have to implement MHPS. It has to be incorporated into doctors' contracts. NHS Foundation trusts, in theory at least, have the ability to deviate from MHPS and move away. It's not mandatory. But in practice, most foundation trusts, if not all, have a form of MHPS in place. Foundation trusts sometimes will vary some of the provisions and make them a little bit more usable, but in general terms, we haven't come across a foundation trust that's fully moved away from MHPS. And the reason I say that is because wherever you go within the NHS, you can guarantee that you'll find some form of MHPS. If you're in Wales, there is a version of MHPS. It is different, but I'll mention that briefly in relation to one of the cases towards the end. But the essence of it is the same. So wherever you go, you're likely to find MHPS in some form. It is fundamentally an HR framework. That's the way to look at it. And it is fundamentally a series of steps and procedures to follow in relation to doctors. But it is unusual in that the protections that it offers to doctors and dentists are particularly staunchly defended, which you might understand. So with the defence organisations and doctors having access to resources, the protections in MHPS are particularly well defended. So if you're running an MHPS process, you can anticipate that you will face challenge, not just from the defence organisations, but very often from lawyers who are instructed either directly by doctors or dentists or by the defence organisations themselves. And I should say, I've said at the beginning, but this is a framework which covers both doctors and dentists. I will no doubt slip into just referring to doctors, but when I say doctors, you can substitute doctors and dentists throughout the session. The other thing which makes it unusual from an HR perspective is that there is a role for an independent third-party organisation, in this case, Practitioner Performance Advice, PPA, which was formerly the National Clinical Assessment Service, or NCAS. So if you see any reference to NCAS, these days it's called Practitioner Performance Advice, PPA, but it's the same organisation. It's run by NHS Resolution, and the intention is that it provides these third-party independent services to NHS organisations to help them to manage and resolve performance issues in particular, and to provide impartial advice. And as I go through this session and I talk about the stages of MHPS, there are certain points where the framework encourages you and strongly advises you to contact PPA. And there's one or two places where you have no choice, but you have to contact and involve PPA. And I'll make that very clear when we come to those parts. So that's really just the background. And we'll come back to some of those issues in due course, but that's just to give you a sense of what maintaining high professional standards in the modern NHS is. So there are 5 parts to the framework, and as I said, originally they were introduced in quick succession, but they're now fully implemented. So these are all the parts, and I'm going to look at these in turn, but you'll see from the way that I've divided it there that broadly MHPS deals with 3 different categories of concern. One is conduct, one is capability, and the other is ill health, and I'll talk about each of those in turn. So the framework is not intended, absolutely not intended, to be substituted for what I would describe as normal management action. So if you are managing doctors, it's not intended that everything is an MHPS issue. Not everything is covered by the framework. And in fact, it encourages informal action, the normal things that managers would deal with and do, training, supervision, and so on. And if possible, dealing with any concerns which arise in relation to doctors or dentists in an informal way. But of course, that's not always possible. And you may well have to get into formal action and therefore start the MHPS framework, the process, where there is a potentially serious concern. Serious concern is not defined in MHPS, and so there isn't a clearly defined threshold when the MHPS framework kicks in. That's a matter for each organisation to determine. And so when there are a series of concerns or one concern, the organisation itself has to determine whether MHPS applies and whether to start an MHPS process. And as I say, there isn't any definition and there isn't any guidance in MHPS, but there are things that you can look at for examples. And so you can get a sense of the severity of things that are necessary to amount to a serious concern. There are conduct examples in MHPS, so you can see what they are there. Things like refusal to comply with reasonable requirements of the employer, infringement of the disciplinary rules, including conduct that contravenes standards of professional behaviour, commission of criminal offences, and willful, careless, inappropriate or unethical behaviour likely to compromise standards of care. So you can see the types of misconduct issues that are envisaged by MHPS. That's not at all exhaustive. These are only examples of the sorts of things that might form part of a serious concern under MHPS. And then there's also this NHS resolution document, how to conduct a local investigation. And if you look at that document, you can see there are further examples or categories of things which again might amount to serious concern. One thing that is worth noting is that it's not just about the exercise of clinical skills. You'll see from the bullet points there, it could be, for example, a financial concern. It could be that a doctor is fraudulently or allegedly fraudulently putting in expense claims, for example. That would be covered as a serious concern. So it's not just about clinical issues, it's much broader, and it could amount to a serious concern, for example, if a doctor is consistently working outside of practice guidance or standards. So it's pretty broad. And as I say, it's down to the discretion of each organisation to decide whether or not that threshold has been crossed, and therefore, if it has been crossed, that you start the formal MHPS process. For doctors and dentists in training, there is a presumption that issues will be an educational issue. So there's a presumption that can be rebutted, and it's not always the case, but there is a presumption that concerns will be educational in nature, and therefore you should involve the Let Be Health Education England and involve them in terms of the training of the practitioner. Now that won't always be the case, and there will be cases where clearly something is not an educational issue. If a junior doctor comes in, punches a colleague in the face, pretty clearly not an educational issue, pretty clearly a misconduct issue, and therefore you would go through the MHPS process if it was serious enough. But for those issues which are primarily educational, you deal with the third party, deal with Let Be and the HEE. You're encouraged to involve practitioner performance at an early stage, and so it makes sense if you have a concern about a doctor, serious concern, for your medical director, and it usually is your medical director or chief medical officer, to speak to PPA and take their guidance right from the early stage. You don't necessarily have to do that. There is some ambiguity in the framework about whether you have to do it right at the very beginning, but either way, I'd strongly encourage you to pick up the phone to PPA, set out the circumstance and set out what you're intending to do as an organisation in relation to the doctor or dentist. As a general point, as long as you are sensible and you're following MHPS, it's extraordinarily unlikely that PPA will disagree with what you intend to do, but they very often can give you some additional practical advice for dealing with the concern. So it's well worth involving them right from a very early stage. So once you have crossed that threshold and you've decided that there is a serious concern or serious concerns, there are certain things that MHPS requires you as an organisation to do. The first is that serious concerns have to be registered with the chief executive. You might wonder why that is the case, but it goes back to the concerns that were raised before MHPS was implemented. There was a series of concerns about the lack of accountability, with all sorts of stories of doctors being excluded and staying off work for years and years without very much scrutiny or accountability. And so there are various points in MHPS where the organisation is accountable in some form to either senior board leaders or in some cases outside of the organisation itself. But the starting point is that the chief exec must be cited on these serious concerns right at the very beginning. And the chief exec then has to ensure that there is a case manager who is appointed to manage the case. Under MHPS, for clinical directors and consultants, it must be the medical director. For other cases, the medical director can delegate. So it could be, for example, clinical director or somebody of that sort. This is one of the areas where foundation trusts sometimes have moved away and allowed more delegation for case manager roles. But MHPS itself talks about clinical directors and consultants having the opportunity to be managed by the medical director only. Once the case manager has been appointed, they will discuss the appointment of a case investigator with the HR director, or these days more likely to be chief people officer, and the medical director if the medical director is not the case manager. And the case manager then appoints a case investigator. There are key roles in an MHPS process, and I'm going to talk about those in the next slide. But the first two, and most important in many ways, are the case manager and then the case investigator. The chair of the organisation has to appoint a non-executive director as a role known as the designated member. I'm going to come back to that when I talk about the roles next. So those are the first stages. If you think about it as the structure, that's the structure of an MHPS process right from the very beginning: case manager, case investigator, designated member. Looking then at each of these roles, case manager, you won't be surprised to learn, manages the case. They oversee the process at the initial stages. Their obligation is to ensure that there is a fair and reasonable investigation that's taken place, but they shouldn't be involved. So the case manager sometimes might want to be involved in the investigation itself, but the strong advice and the MHPS framework suggests that shouldn't happen, that you shouldn't be involved directly in the investigation. Your job is to set it running and then back away until the investigation is finished, pretty much. The other obligation on a case manager, which sometimes can be missed, is to ensure that there is appropriate support for the doctor or dentist going through the MHPS process. And in fact, I'd extend it. Although it refers to the practitioner, I think it's easy to forget that the case investigator, those people that might be called as witnesses, anybody associated with an MHPS process might need support, might need some form of assistance to get through what can be a very difficult process. The key role for the case manager, certainly in the early stages, is that once the investigation has finished, they make a decision on which path to follow once the investigation's finished. So the case manager will receive the investigation report, might be further clarification, but they will then make a decision about which way this process proceeds. And I'm going to come back to that because it is an important aspect of MHPS. So that's the role of the case manager. Case investigator, like all HR investigators, should be appropriately experienced or trained. MHPS is specific in saying that they must be appropriately experienced or trained. So, for example, you might have somebody that's doing their first MHPS process, but as long as they understand the process, as long as they have sufficient support, that should be okay. But either or, I mean, ideally appropriately experienced and trained, but either or is what MHPS requires. They should work within terms of reference and make sure that they stick to those terms of reference. Very often with MHPS investigations, the doctor or dentist is also going through other HR processes, so it's important that the investigator sticks to their terms of reference and understands what they are. Communication is important as well for this role. MHPS processes take a long time, very often. The investigation should take, under MHPS, 4 weeks. The reality is they don't very often at all. And so it's important for the investigator to keep everybody aware of progress and anticipated timescales. They plan the investigation and they keep records. It's very much the discretion of the case investigator to decide how the investigation is run. Of course, they collect evidence, they analyze the evidence, and then they write the report, which goes through to the case manager. The third role under MHPS is in many ways the not the less important, but the least important, but certainly the least used role, if I can put it that way, which is the designated board member. And again, if you go back to the origin of MHPS, the intention was to have a degree of scrutiny and to appoint a non-executive who would have a degree of scrutiny over the process to make sure that things were kept on course. In practice, we don't see too much activity by designated board members, and that's not a criticism of them, but it's more about the fact that the doctor and their representatives are going to focus their concerns or their questions on the case manager and or the case investigator. But the non-execs are there to exercise this degree of scrutiny, to maintain momentum, make sure that happens, make sure timeframes are observed. Most importantly, and this is where we see it in practice, to hear representations from the doctor or their defence organisation. So very often where they do get involved is if the practitioner's got a concern about either the way in which the process is being conducted, or most often the delays associated with the process. And also the designated board member should be kept informed of exclusions. I'll come on to talk about exclusions in a moment. But those are the 3 key elements, 3 key roles of an MHPS process. Once those roles have been filled, once we have people in place, there are some initial actions. And some of these, again, will seem fairly obvious, but I just want to make a few points about each. The case manager must write to the doctor or dentist to inform them that they are being investigated under MHPS, the name of the investigator. You don't always have the investigator sorted by the time you write to the doctor, but if you haven't, you should tell them later. But either way, they know there's an investigation. They should know the name of the investigator. And also to set out specific allegations and concerns, the nature of the MHPS investigation. One of the things that we see not being done very well is that aspect. So often we see doctors being informed that there is an MHPS investigation, but they're facing very non-specific, very vague allegations or concerns. And that's a mistake. So right from the very beginning, as a case manager, you should be able to say these are the specific concerns or the specific allegations that we're going to investigate. Now, it may well be, and it's likely in some cases, that your first list of allegations and concerns grows. It could narrow. It could be that, over the course of the investigation, it turns out that the allegations have no weight. but very often they grow. And so we've had cases where there might be one specific bullying allegation against a doctor, and then when the investigation starts, people come forward and you find that the allegations have expanded. That's fine, as long as there is a genuine and reasonable reason why the investigation needs to expand, and that everybody's informed of that. So the case investigator and the doctor themselves knows that the investigation has been expanded. It's better to start with very specific allegations that can be reasonably expanded if necessary, than to start with very vague allegations. Because what will happen is the defence organisation will simply come back to you and say, we don't understand these allegations, they're too vague, and our members not prepared to be interviewed until we understand what the concerns are. So to preempt that, make sure that they're very specific. I mentioned at the beginning that there are protections that are defended, and doctors and dentists under these procedures do have certain rights, some of which are over and above what another employee might have. And so there's a number of those. The first is the opportunity to see relevant correspondence. There is very often a push by the doctor or their representative to see everything, either before they're interviewed or afterwards, but either way, they want to see every piece of information. That isn't what MHPS gives them the right to see. They have the right to see relevant correspondence. And in a recent case of Byrne against Alderhay, the courts have said that's exactly what it means. What it says is what it means. You have the opportunity to see relevant correspondence, but no more. So you don't necessarily have the right as a doctor to see detailed medical records or anything of that sort. But as an investigator, you want to be able to give the doctor enough information, of course, to be able to answer intelligently the questions that you put to them. So there's always a balance to be struck about giving information, but that's the requirement under MHPS framework. The doctor or dentist also has the right to see a list of those people that are going to be interviewed, and they can, of course, add and suggest people to be interviewed, but they have a right to see the list of people that are to be interviewed. Like everybody in an HR process, they have the opportunity to put their case to the investigator and to make their points, and they have the right to be accompanied, which has been the source of a lot of disagreement over the years and judicial consideration, but has been relatively resolved. So the right to be accompanied is a right at any stage of the procedure. And so right from the very beginning, as soon as there's an MHPS process in place, they have the right to be accompanied. And they have the right to be accompanied by a fellow worker, an official or lay representative of a trade union or defence organisation, friend, partner or spouse. And this is the bit that over the years has been considered in a lot more detail. What MHPS says, and I can guarantee what your policy will say, is that the individual may be legally qualified, but he or she will not be acting in a legal capacity. You might wonder what that means, and so did the Court of Appeal in the case of Kulkarni against Milton Keynes NHS Foundation Trust, and they concluded that this expression was devoid of meaning, doesn't mean anything. Their view is that once a lawyer has been admitting it as a representative, they'd be entitled to use all of their professional skills in the practitioner's service. So it doesn't mean anything. And you will see lawyers acting on behalf of individuals as long as they are instructed by a defence organisation. There's no reason why they can't be the companion for a doctor. So, I mean, in practice, you don't see that in the early stages very often. You see it often at hearings. I've advised panels and I've represented trusts in hearings where they've got a barrister acting for the doctor in the internal process, but they don't usually appear until the formality of a hearing. Very often defence organisations, as you would expect, are there in the early stages. They might attend an investigatory interview, for example, but legal representatives tend not to get involved until the final stages, but it is something which is allowed under the provisions. I'm going to talk about restrictions first because very often in these cases there are concerns about leaving the practitioner to continue their practice without restrictions. And the thing to emphasize here is that restrictions are the first thing you think about. So we'll come on to exclusion, which is the same as suspension for other employees, but restrictions are the first thing you consider. So you look overall at the situation, you look at the concerns, you think about whether or not you need to restrict somebody's practice. Now, in some cases, you may not need to. It may be that the nature of the concerns is such that you can manage all of any concerns you might have without any restrictions. But most commonly, there'll be some form of restriction on the practitioner. And that restriction or restrictions can be of any sort. So you have to just consider what's reasonable in all the circumstances to protect not just the doctor, but also patients or other staff, for example. Those sorts of restrictions could be any of the things I've listed there. Very often it involves an adjustment to existing clinical duties. Very often it might be limiting to non-clinical duties if there's a serious clinical concern. I've mentioned there obtaining undertakings. Undertakings are just promises, more serious promises than just a promise. But the idea is that if you have a concern about a particular procedure, for example, you could say to the practitioner, are you prepared to undertake that you will not do that procedure? And that may be enough, as long as other people are aware that the doctor is not allowed to undertake that procedure. Their promise, their undertaking that they won't do it may be enough to satisfy your medical director or whoever the case manager is that there is no safety concerns. There might be others. I mean, these are just the most common types of restriction, but there may be others that you can put in place. There will be occasions, and they should be a rarity, but there will be occasions where you decided that you can't restrict the practitioner's practice enough, and that it needs to be more draconian, and that you need to exclude the doctor or dentist. Now, as I just mentioned, exclusion is the way that MHPS refers to what would be a suspension for any other employee. So other employees are suspended, doctors are excluded. The logic of that is that sometimes, of course, the GMC will suspend a doctor's registration. And the idea is that just to be clear, exclusion is a different word because that relates to the suspension of the doctor, but only within their employment, not on a professional regulation basis. So exclusion just means suspension. When would you do that? Well, you need to protect the interests of patients in some cases, or where you think there's a risk that the practitioner's presence would impede the gathering of evidence for the investigation. So we've had cases over the years, for example, where early on the doctor has tried to persuade witnesses to give certain evidence. I had a case where a doctor tried to persuade their PA to change records. Clearly, in those sorts of cases, there is an obvious risk that they're going to try and interfere or impede the gathering of the investigation, and gathering of evidence rather, and that may be a sufficiently serious reason to exclude. If you decide to exclude, and there are two different types, but if you decide to exclude, it's important to keep a full contemporaneous record of the reasoning behind the exclusion. The reason I say that is because exclusions are very, very often challenged. Sometimes in the courts, but certainly by the representatives or the companions who will challenge, and the doctors themselves will challenge the basis for restrictions, or in this case, exclusions. MHPS envisages two different types of exclusions. One is an immediate period of exclusion, which can't last more than 2 weeks. And the logic behind that is that you might need to undertake what's described as a preliminary situation analysis. So, for example, you have a very serious clinical issue. It appears that it may be the fault of a particular clinician. It looks as if it's very serious. You may decide that you can't put in place sufficient restriction to enable you to try and get to the bottom initially of what the concerns are. And so an immediate period of exclusion is not that uncommon. And as I say, it can last up to 2 weeks. It gives you the opportunity to establish the basic facts. At the end of that 2-week period, or otherwise, you may decide that the doctor or dentist needs to be formally excluded. And the way to think about that is that it's in effect blocks of 4 weeks at a time. So every 4 weeks, at least, the exclusion, the formal exclusion, has to be reviewed by the case manager. They have to make a decision about whether it's going to continue. There are some other rules, and they are fairly complicated, but I've set them out in brief here. After 3 periods of exclusion, the organisation has to consult with practitioner performance advice and has to report to NHS England, or the designated board member and the board. So you have to report after 3 periods of exclusion, in other words, after 12 weeks. And then after 6 months, there must be a further consultation with PPA. And again, the report has to go to the designated board member, the board, and NHS England. So there is a degree of accountability. The other provision under MHPS is that exclusion should be limited usually to 6 months or less, unless there's a criminal process which is ongoing. And there is some useful PPA guidance which I recommend, which you'll see the link when you get the slides on exclusion. So have a look at that. But it is an area that's very often challenged by doctors, very often. So that's exclusion. Just want to come back to the investigation very briefly for one slide, just say a few things about the investigation. I mentioned that the investigator needs to stick within their terms of reference, which is really important. The standard for these investigations is no different from any other HR investigation. The investigation must be within the band of reasonable responses, which really envisages different types of investigation. So MHPS investigations could be extraordinarily thorough and you investigate every aspect, or it could be thorough enough. So there is a band of reasonable responses from an investigator. Critical that you have those terms of reference, critical that as far as possible the investigator has an independent mindset. The only thing in MHPS which is express, which I would say applies to all investigations, but the only thing which is express is that you as an investigator should look for evidence that does not support the allegations as well as evidence that does. In other words, you should be independent. You should be looking for things which might contradict the evidence, the allegations rather, as well as the evidence that supports those allegations. Again, it's all about being independent and fair-minded. So once the investigation's finished, it goes to the case manager. And the case manager, as I mentioned earlier, has to decide about the pathways that they then follow once they have the concerns fully investigated. The first question is, are the concerns still valid? Has the investigator discovered anything which might completely undermine the allegations? Are the concerns still there? In some cases, the case manager may look at the investigation and say, look, actually, there is no case to answer. There's nothing to take forward. And the MHPS process therefore comes to an end. Most commonly, though, the case manager will reach the conclusion that the concerns are still valid in some form. And if they reach that conclusion, they then need to determine what the nature of those concerns are. Unusually, for what is basically an HR process, you only reach that conclusion once the investigation has completed. If you think about for other employees, you reach that conclusion at the beginning. So if you see a concern, you reach the conclusion about whether it's capability, ill health, conduct. You do that first because that then determines what policy you follow. Under MHPS, it's the other way around. So under MHPS, you don't reach the conclusion about what the concern is until you've had the investigation. Which in some ways makes more sense, but that's the way it works. So the case manager needs to decide, is it conduct, is it capability, is it ill health, or is it something completely different? But those are the three elements that are covered under the framework. What do you do when the issues are both conduct and capability, and they are very mixed? The process is that you would usually deal with those as capability. That's one of the things MHPS is very clear about. But if the misconduct issues are separable, so if you can split them off, then you can deal with them as separate misconduct cases. So for reasons that will be obvious when I talk about capability, it's generally in the practitioner's interest for matters to be treated as capability because it's a lengthier process and a more complicated process. Equally, it's generally in the employer's interest to say that things are conduct because, again, the process is simpler for them and quicker generally. But if there is that genuine overlap, MHPS requires you to deal with the issues jointly as capability, unless, as I say, you can properly separate the concerns about conduct. If the doctor's not happy with your category, so let's say the case manager decides, what am I looking at? I'm looking at conduct issues, and therefore we go forward on that basis. The practitioner can raise a grievance. So they can complain about the way in which the concern has been classified, but ultimately it's for the employer to make that decision. So they can raise a grievance. You'd have to go through your normal grievance process, but ultimately it's for the employer to make a decision about what category the concerns are at this stage. So let's look first at capability. So this is if the case manager's decided that either the issues are mixed or there is a pure capability issue. The case manager looks at the report. The practitioner has to be given the opportunity to comment on the factual content, so they have an opportunity to do that within 10 working days of receiving the request. As a matter of practice, the practitioner will understandably very often go further and comment beyond the facts set out in the investigation, which is fine, because at least that way they've given you their thoughts on the investigation, but they must have the right to do that in a capability case. And then based on comments from the practitioner, based on probably advice from PPA, because that's sensible, case manager will then decide on further action. That could be at this point exclusion or temporary restrictions. And on top of that, they would have to look at whether there are possibly local actions that could be taken. So can we manage this without a formal hearing? Can we take action to support the practitioner and make that decision? If the decision's taken that they can't do enough, the organisation can't do enough locally, the concerns are sufficiently serious, then it has to be referred to PPA before you can take any formal action. This is one of those places, there aren't very many, this is one of the places where PPA, practitioner performance advice, have to be involved. And there's a series of cases on that point. You have to send them out to the PPA. They will then assess what they find, what they see. Very often that will involve a proper assessment of the doctor. They will come in and do an assessment of the doctor. And then if they think it's appropriate, they will set down an action plan for improvement in terms of capability. And again, if that's where you get to, that decision has to be communicated to the practitioner within 10 working days of receiving the comments from PPA. So you have potentially an action plan which is set up by PPA if they decide that that's a sensible way forward. Now, there are occasions when they'll say, we don't think that this is something that can be resolved for an action plan. We don't think that our involvement is going to be helpful. And at that point, the involvement comes to an end and you can move these things forward. As I say, you must refer it to PPA. If they produce an action plan, the organisations are not bound to implement if they have good reasons not to. So we've had cases, for example, over the years where PPA has come up with a perfectly good plan, but the problem is, for reasons which are very local, the organisation cannot implement that plan. So if they can't provide sufficient level of supervision, for example, or if there just isn't the facility to provide what needs to be provided under the plan, the trust can make a decision, the organisation can make a decision that it can't proceed with the action plan. Now, in those circumstances, if the concerns are still there, then you need to move forward to a hearing, a formal capability hearing. Or indeed, if there has been an action plan and it's failed. So either there's no action plan, there's an action plan which you can't implement, or there's an action plan which has failed. Things proceed to a formal hearing. There are plenty of procedural aspects to a capability hearing. It's one of the reasons why it's a complicated process, and one of the reasons why doctors generally prefer to go through a capability process and trusts generally prefer not to. So I'd have a look at the provisions if you're in the capability process, but broadly they are these: that the practitioner has to be informed in writing at least 20 working days before the hearing, including the details of the concerns that are going forward and the arrangements for the hearing. At least 10 working days before that hearing, there must be an exchange of documentation, both from the practitioner and from the organisation, including witness statements, if appropriate. If the practitioner asks for a postponement, which sometimes they will do, there has to be a reasonable response, bearing in mind that extension should be kept to a minimum. You can, in some cases, but they are rare, proceed in the practitioner's absence, but only if it's reasonable and not normally less than 30 working days after the original date. I mentioned health considerations there. The only cases, I think, in which we've had a hearing go ahead without the practitioner being there is in long-term sickness absence cases where they were able to send a representative but not attend themselves. But it's unusual for these matters to go ahead without the practitioner being present. And if there are health considerations, then there must be normal absence procedures and occupational health involvement, try and move things forward. So you can see probably already from that a capability process, and some of you may have already been involved in a capability process under MHPS, but you can see that it's a complex and long process to go through generally. In terms of the hearing itself, so if you get to that point, then you have to ensure that the panel is appropriately composed. 3 people, usually 2 board members, senior staff, and an external medical or dental practitioner. So just pausing there for a moment, this is again one of the unusual aspects of MHPS. You have to involve, for a capability hearing, you have to involve an external medical or dental practitioner. And it's usually going to be chaired, the hearing itself, by an executive director. So it's a very senior panel, and it has a degree of independence from outside the organisation. In addition to that, there should be 2 advisors to the panel. One is a senior HR person, as you would expect perhaps, and the other is a senior clinician from a similar specialty to the practitioner. And you might ask, why would you need that if you already have somebody on the panel who's external? And the reason for that is very often the external panel member is not somebody that is of the same specialty as the doctor or the dentist. So the external medical person might be a medical director from another trust. There's no guarantee they'll have that specific clinical experience, and therefore you can have, and in fact you should have, set up a senior clinician to advise the panel if there are issues around specific specialty. In terms of the conduct, it's set out in the process, presentation of both cases as you would expect, pretty standard HR process, questioning and clarification of witnesses and clarification of cases by the panel, and then closing statements. So pretty much what you would expect from any hearing, but that's what's set out under MHPS. The panel itself can conclude a range of decisions. They can decide that no action is necessary, there's no case to answer. They can impose an oral or a written warning. Can be a final warning, or it could be the termination of contracts. It could be a dismissal. And once they've made their decision, they should communicate that to the parties within 5 working days of the hearing. Now, again, just to pause there, the timetable is tight, and in a complex MHPS process, it may well be that you're not able to do it within 5 working days. The key thing is communicating if that's going to be the case, if there's going to be a delay. And there needs to be written confirmation of the decision, including the reasons for that decision and appeal rights. So it's a fairly complex process. And as I say, it does take usually a long time. Conduct, however, is a much simpler process. So if you've reached the conclusion as a case manager that the issues are in fact conduct and you can deal with them as conduct, the normal disciplinary procedures of your organisation will apply. Particularly in relation to professional misconduct, you're strongly advised to seek advice from PPA at this point, but you're not required to, but you're strongly advised to. And if during the course of the investigation, the investigator thinks that matters are professional misconduct, they should seek independent professional advice. Now, on the distinction between professional and personal misconduct, I will come back to that because we've had some recent clarification on what the differences amounts to, but I'll come back to that point. So in line with your disciplinary procedure, there needs to be a formal hearing. It's subject to the normal rules, whatever your normal rules are. The case manager usually presents, and usually the case manager is there as a witness. It can be, in some organizations will do it differently. Some organizations will have the case investigator presenting. Doesn't really matter as long as there is some presentation of the case against the practitioner. And where the matters are professional misconduct, the panel must include a medically qualified member from another NHS body. So there is a similarity with capability cases because there has to be that external qualified member from another NHS body. You don't need the specialist advice from HR or from a panel member, from a specialty medic, but there must be a person on the panel who is medically qualified from another NHS organisation. So that's conduct and capability. Finally, just looking at ill health, because that's the third element, or third category rather, under MHPS. In principle, it's treated the same way as it would be for any ill health issues with any other employees. So looking at treatment, rehabilitation, retraining, looking at reasonable adjustments, if that's a possibility, or whether it's something that needs to be put in place. So things like move locations, remove duties, change hours, that kind of thing. You should involve PPA, so you discuss it with them in terms of your process. And then ultimately, if that doesn't work, so if the ill health concerns continue, you go back to treating issues as capability. So all the stuff I've said about capability is how you would treat an ill health case, and go through a formal process in that way if matters don't improve. But the emphasis is very much upon helping and supporting the doctors, both in capability cases, actually, in terms of performance, but also in terms of ill health. So those are the three pathways. Just before I move on, I wanted to say something that's not on the slides, but some of you may have questions about it, so I'm going to preempt a little bit. If it's not one of those matters, so if we're not looking at ill health, capability, or conduct, you might, in theory, be looking at what lawyers call some other substantial reason, which would be things like breakdown in relationships. That's not covered by MHPS, and that's not why I've not put it on the slides. But SOSR, if that's where you're proceeding, is not an MHPS matter, and you'd proceed outside of the framework. If anybody's got any questions on that, very happy to take them, but just want to mention it at this point. The final thing before I move on to third-party involvement is just talking about appeals. I've set out in the slides a fair amount of detail about how to deal with appeals in terms of capability, primarily because for conduct cases, you just follow your own policy. And I don't want to deal with it in great detail, but I've set out in some detail there, so you've got the information for your purposes later on when you get the slides, which we'll be sending out after this session. But just a few things to point out. This is not something for an appeal around capability. It's not something that is going to be a complete rehearing, but you can consider new evidence if somebody is able to produce that. Really, the purpose is to establish if the procedures have been followed and the decision was fair. The appeal panel is, if the capability panel is thought of as independent, the appeal panel for a capability hearing is even more independent, because there needs to be an independent chair from an approved pool, and that's from a list held by NHS employers. So it's somebody completely external to your organisation. That's one member. There must also be a trust chair or chief or non-executive who's appropriately trained on the panel, and there also needs to be, again, an external medical or dental member. So very independent process, very inevitably very lengthy process because of the way these things take to get organised. And again, they can call upon specialists for advice, consultant from the same specialty or HR specialist. Timeframes I've set out there, you can see that. So again, it's, in theory, it's pretty tight in terms of timing. In reality, very often it takes much longer. The process for an appeal, exactly what you would expect. The representation can be there by a companion. Both parties present their case and their statements. Witnesses can be called if necessary with 10 days notice. Very often the panel will want to adjourn to consider the information they presented, the evidence they're presented with, and in some cases they might want to rehear the case or send it back to be reheard. So there's plenty of discretion on the panel. They can confirm or vary the original decision. They can order the case to be reheard if they think procedures weren't followed. They can consider new evidence and the potential impact on the original decision, and reach a conclusion. There's no appeal there's no pay rather during the appeal against dismissal, but if somebody is reinstated, then of course they get back pay if the appeal is upheld. And again, the appeal needs to be done within 5 working days of the decision. That very often, unfortunately, it slips because often these things are very complicated. So that's just to give you a sense of appeals. They are complicated in capability cases, but it gives you a sense of what's required. Right, and I wanted to look at third-party involvement fairly briefly before looking at some recent cases, and then we'll have time for Q&A. So very often in doctors' cases, third parties are involved. I've already talked about PPA and their role and what they do, and so hopefully you get a sense of their involvement, but very often other third parties are involved as well. These issues can sometimes include criminal matters, and MHPS says a few things about criminal issues. First of all, that you must report suspected criminal action to the police. No great surprise there. But it goes on to say that the trust investigation should only proceed in respect of those aspects of the case which are not directly related to any police investigation that's already underway. And the short answer to the question about what you should do is always consult with the police. Discuss with them what you're intending to do as an organisation, take a view from them and take their instructions, really, because that's what you're doing, on whether or not that's acceptable, whether you can proceed with the investigation. Now, there's no hard and fast rules, and we've had plenty of cases where we anticipated the police would say you can't investigate under MHPS, and they say actually you're fine, you can go ahead. And we've had other cases where we thought it would be fine, but the police have said no. I mean, there probably are very, very exceptional cases where you might take issue with that with the police, but generally speaking, you'll comply with that requirement. You don't want to end up being accused of interfering with a police investigation, of course. And so that may lead to some frustration, though, because it may be that your MHPS investigation has to be paused or delayed whilst the criminal process starts and takes some form. In cases where there's potential fraud, you might want to involve, or you will want to involve NHS counter fraud, and they themselves again may ask you not to investigate, not to inform the employee, not to do anything under your MHPS process until they've got their investigation finished or at least underway. Sometimes we get asked questions about criminal charges or criminal allegations where the conduct is outside of work, and the very short answer to what can be a complicated question is, really, does it impact upon their role? And so there are some obvious cases. If you've got a consultant, for example, who's accused of a very violent offence, clearly that has an impact upon their role because they would be seeing patients, and we don't know whether they're going to have potentially some negative impact on patients. So, but there needs to be some connection. So if there are criminal charges which relate to things outside of work or criminal allegations, it's fine to take action under MHPS, but there has to be some connection before you're able to do that. Even in cases where criminal cases have gone all the way and there is no conviction, that doesn't prevent you from taking action under MHPS. The standard of proof is different. So under criminal processes, it's beyond reasonable doubt. The standard of proof in an MHPS case, like all employment cases, is the balance of probabilities. So it's not unfair necessarily for somebody to be found not guilty of, let's say, an assault, but for you as an organisation to reach the view, because the balance of because the burden of proof is different, for you to reach the view that they probably did undertake the assault, and therefore they're dismissed through an MHPS conduct process. So there's no contradiction with that. There's no problem with that. You may well be able to proceed anyway, even if there's no conviction. Some of these procedures, or in fact most of the procedures under MHPS, will at some point have a crossover with GMC issues. There is, though, a distinction between fitness to practice, which is very much a GMC issue, and the fitness to undertake the role as an employee, which is an MHPS issue. So there's the internal process and there's potentially the GMC process. Anyone can refer a doctor or dentist to the GMC, or GDC as it is for dentists. Anybody can refer at any stage. In these sorts of cases, you're most likely to consider referral once you've reached the point of having a hearing and you've reached a decision. That's not always the case. It may well be that you are afraid that the doctor, for example, might be working elsewhere without your knowledge, and a referral to the GMC is about all you can do in those situations, to report the doctor to make sure that they're on their radar. In practice, you will take a view from the GMC because your medical director will have meetings, no doubt, with the local employee liaison person. And what we often find is that the medical director will have a no-names discussion with the GMC on a local level and say, do you think we should be referring? So there's plenty of guidance from the GMC on referrals, but ultimately it's for the trust to decide whether they're going to do it. But as I say, anybody can make a referral. It could be from another doctor, for example. In most cases, the GMC will wait for the employer's decision internally, and so very often they will want to see the outcome of an MHPS investigation, maybe an MHPS hearing, before they take action in terms of the regulatory process. But that's a GMC. Just very briefly and finally, the other thing to be mindful of is the potential for what we call an HPAN, Healthcare Professional Alert Notice. These are issued by NHS resolution to inform NHS bodies and others actually about health professionals who may pose a significant risk of harm to patients, staff, or the public. So it's something that may occur depending upon whether or not there is a concern raised about them working for other organisations. And it's usually when the GMC is considering the concerns, and it's an additional safeguard on top of any GMC restrictions during the pre-employment checking process as well. So you can check for an HPAN notice. If you have any detailed questions about HPANs, I won't be able to answer them because I've never actually been involved in issuing an HPAN or seeing an HPAN, but we're aware of how they work. So it's very much something that's issued by NHSR, but something you can check as an NHS employer. Right, so very briefly then at the end, I just picked 3 cases which illustrate different aspects of MHPS. MHPS cases generally don't come along very often. So we keep an eye out for any recent MHPS cases. These cases all go back a few years because not many MHPS cases reach all the way to the appellate courts. So you might have an employment tribunal, for example, that involves MHPS, but it's very often the cases of interest are when they get to the Employment Appeal Tribunal or the Court of Appeal. So these are all cases, the ones I've chosen illustrate various aspects of MHPS, and I thought they'd be helpful. The first is case of IDU against East Suffolk and North Essex NHS Foundation Trust. This was a consultant who was a consultant in emergency surgery and was accused of a whole variety of misconduct. So I've given you some examples there. Holding herself out as clinical lead after being told to stop doing that. She declined job plan meetings when she wasn't actually busy. She refused to cover junior doctor industrial action. So things like refusal to follow reasonable management requests and so on. In addition to that, she was rude to colleagues, and the trust was looking at the allegation of whether or not she had become unmanageable. They concluded that she had, and so she was summarily dismissed for gross misconduct, and she pursued actually a large number of different claims in the Employment Tribunal, including whistleblowing and other forms of discrimination. But she lost her claim in the Employment Tribunal and then proceeded to the Employment Appeal Tribunal. Primarily, she was looking at the characterization of the concerns under MHPS. So just to flick back for a second, just to remind you, these concerns are there. So the concerns are failure to accept reasonable management instructions, rude to colleagues, and had become unmanageable. She said that the characterization was wrong and there was an issue about whether it was capability or conduct. She said it was capability. But if it wasn't, she accepted that if it wasn't capability, then she thought it was professional misconduct, if it was a form of misconduct. And these were the issues before the Employment Appeal Tribunal. And the consequence, of course, for that is that if the Employment Appeal Tribunal had concluded that it was in fact capability or professional misconduct, then the trust had gone wrong on procedure because they hadn't included an external person on the panel and they hadn't referred matters to what was then NCAS, now PPA. And remember, you have to do that if it's a capability question. So it's a key issue for the EAT, and the EAT dismissed that appeal. They said all of the issues that were of concern were of personal misconduct, not professional misconduct. She then appealed to the Court of Appeal, and this is why this case is interesting, because it gives us guidance on the distinction between personal and professional misconduct under MHPS. Court of Appeal upheld the EAT decision, and they provided this guidance. They said, as a general principle, professional conduct arises from the exercise of medical skills. That's usually in the course of treating patients, doesn't have to be, but it has to be in the exercise of medical skills. In those cases where it's unclear, so in those cases where they're borderline, the question you should ask as an employer is whether the issues require the experience and expertise of an independent doctor. And in this case, they didn't. So in this case, the Court of Appeal were prepared to accept that they didn't involve the need for independent clinical expertise. And what they said was, look, in this case, being a doctor was just context for these allegations. If you think about the allegations, refusal to follow reasonable management request, being rude to colleagues, all of these things are things that could happen in any sector, in any context. There's nothing unusual or unique, rather, about being a doctor, a clinical practitioner in this case. The sorts of concerns that the employer was facing were very general concerns. So there was no requirement to have the independent skill and experience of a clinician, and it was very much personal, not professional misconduct. So very helpful guidance if you're making that decision about whether to count something as professional or personal. This gives you some very clear guidance on how you make that decision. A completely different case, and this does involve, I mentioned it earlier, but it involves the Welsh version of MHPS, which is called Upholding Professional Standards in Wales, UPSW. I don't know if there's anybody on the webinar from Wales, but the process is very, very similar to MHPS. There is a difference. There are, for example, there's what's described as a standard and an extended process, depending upon the severity of the allegations. But very broadly, it's very similar to MHPS. So for these purposes, there's no distinction in this case. So Mr. Smo worked for this organisation, the Health Board, and there were concerns about his conduct and capability, and there was an investigation under MHPS. The intention of the Health Board was to refer him to PPA for capability and then have a formal hearing for conduct. So both elements were being pursued. But then they made the decision that they would investigate whether the relationship with colleagues had broken down. I mentioned earlier on some of the substantial reason dismissals. And so having already started both a capability and a conduct process, they intended to start a third process, which would have been an investigation into breakdown of communication. One thing that doctors do more regularly than other employees is bring injunctions. And an injunction is when you go to the High Court and you say, look, my employer, in this case, is not behaving in a way that they should. They're breaching my contract in some form, and I want you to stop what they're doing. And this is a case where Mr. Smo brought an injunction in the High Court to stop the employer from investigating this breakdown in relationships. And the High Court granted the application. They said that there was a breach of the implied duty of trust and confidence in the way that the Health Board was acting. There was significant overlap between the issues in the conduct case and the new breakdown in relationships investigation. And the existing procedures, in other words, the capability and the conduct procedure, should take their course. Why is this an interesting case? Well, I think because there's very often frustration on NHS employers' part that things are not proceeding very quickly. As I mentioned earlier, capability concerns take a long time to fully resolve. And so I suspect, although I don't know, I suspect that the organisation in this case thought that independently looking at the breakdown in relationships issue and the concern was a way of moving things forward in a more timely way. But what the High Court is very clear in saying is that you've got processes in place. They cover adequately the concerns you've got. There's no need for a third, in this case, a third investigation, a third process. So the implication very clearly for employers is this: look, if you've got what's obviously a capability concern, if you've got what's obviously a conduct concern, deal with them in the way that you should under MHPS. Don't always look to a third way, an SOSR process, as a way of resolving these things, because the courts won't take that as being a reasonable way to behave unless there's circumstances which justify it. It's going to be difficult in those cases where you've got clear conduct and capability issues. And then the final case is the case of Greg. This is a case primarily about pay, but also about criminal investigations. Mr. Gregg was employed from 2003 as a consultant anaesthetist. In 2016-2017, there were concerns broadly about whether patient deaths had been hastened by him, and he was put through an MHPS process. Police were involved and the GMC. So far, not that unusual. Very often, these sorts of cases involve both potential criminal action and the GMC. He was excluded on full pay, and then the GMC suspended his registration for 18 months, interim suspension, in May 2017. At that point, the employer lifted the exclusion, but they stopped his pay on the basis that he wasn't able, because of the GMC suspension, to resume his full responsibilities. They planned a disciplinary hearing, and this was whilst the criminal process was ongoing. That disciplinary hearing was going to look at two things: misconduct, but also whether or not he was to be dismissed for lack of registration given the GMC action. Dr. Gregg refused to attend that hearing, and he sought an injunction. So he went to the High Court, and then it went on from the High Court to the Court of Appeal. So I missed out the High Court stage note because I wanted to focus very much on the findings of the Court of Appeal, the decision of the Court of Appeal. So they looked primarily at two issues. The first was the right to withhold pay, and they concluded that the trust did not have the right to withhold pay due to the interim suspension because there wasn't a contractual right to do that in his contract. The question for them was whether he was willing and able to work, and the answer was he was, but he couldn't work because of a third-party restriction, in this case the GMC. So the trust had to keep paying him. The second question for them was whether or not they could proceed with a disciplinary case, even though there was a criminal process which was ongoing. And they concluded that in principle, as long as it wouldn't lead to a miscarriage of justice, there was no reason why the trust couldn't proceed. And in fact, there's a very useful quote, which I'll come back to right at the very end. But they determined that the trust could proceed to a hearing, and they could, in theory at least, dismiss for lack of registration. They didn't say that it would be fair to do that, but they said there was nothing to prevent them from doing it. And just to end on a positive note, they raised the question in this case, Court of Appeal, and they said the following: why should the trust and those who fund it and those who use it wait for a separate organisation to conclude its separate inquiries, which might be months or years into the future? And I say amen to that, because criminal processes and GMC procedures can take a long time. This case is a reminder that doesn't necessarily have to stop NHS organisations from proceeding. And with that highlight, I will end the presentation and we'll have time for questions and answers.
In our organisation, an interim stage seems to have entered between the conclusion of an MHPS disciplinary investigation and a hearing, whereby the investigation report is shared with the individual for something called fact-checking. At this stage, the appendices are not shared with the individual, which leads to some confusion. The full bundle, including the report and appendices, is shared at a later stage, still 10 days before the hearing. Given that, is there any merit in continuing with the fact-checking, or is it MHPS good policy?
It's a good question, and I know organisations that do that. There is only a requirement in relation to capability cases. And so there is that requirement for them to comment, to be given the opportunity to comment on the facts. I wouldn't do it automatically in a misconduct case. The reality is that the practitioner will no doubt comment on the investigation beforehand anyway. So I wouldn't introduce that as a separate process. There's no harm in doing it, but I think it's an extra step that isn't required unless you are looking at a capability process, and not for misconduct. I mean, if you want a sort of blanket approach, because you have to do it for capability, there's no harm in doing it for misconduct cases, but it's certainly not a requirement of MHPS.
When and how should reputational risk be assessed? What if someone is arrested by the police on false allegations, which might pose a reputational risk, but on false grounds, as it were?
Yeah, it's a good question, and I think the answer is at various stages. So if somebody is arrested and that's going to remain outside of the public domain and isn't going to create any reputational damage, then you can look at it at that point, but you're unlikely to be able to justify any action taken on the basis of reputational damage. But contrast that with cases where there's already reports, or at least it's widely known that the individual's been arrested and there is some maybe pushback from the public or whatever, then you can assess it on that basis there. So sometimes reputational damage is the risk of reputational damage rather than actual damage. So you might say, for example, we know this case is going to be reported. We know it's going to be in the public domain very shortly. That's an obvious risk of reputational damage, and therefore we can take action at this point. So it's Reputational damage, of course, but also the risk of reputational damage, which is something you should always have in the back of your mind, I think.
And when, if at all, does a capability warning go on file and remain live for a specific period?
That is a very good question. It depends on the nature of the warning. And I think this is something I'd have to double check, actually, because I think there is some guidance in MHPS on that section. I'm minded to say it should be your normal capability process, but I think actually there is some guidance. I suspect it'll be 12 months. I can double check, but I suspect it'll be for that period of time. It would be open in any event for a capability panel to give it for a longer period of time. But I think there might be some express reference under MHPS to 12 months for final written, but I need to double check, I'm afraid.
If issues at hand are health issues, initially we would be following the trust managing attendance sickness policy with regards to OH review meetings, etc. How does this cross over with MHPS process?
Yeah, again, another really good question. So I think it's right to follow your normal process, whatever the normal process would be. There doesn't need to be, because remember, it's about serious concerns. So if you've got health concerns that you don't think are at that level, and if it's not affecting performance, for example, then it's a very gentle MHPS involvement, because you only really involve the MHPS process if you're thinking about moving towards capability dismissal. So my advice generally is, look, whatever your normal policy is for managing sickness, proceed on that basis. If you get to a point where you're heading towards a dismissal, then technically you're back in the MHPS capability process. So you'd have to make sure you follow the process for that respect. But up to that point, it's really just making sure you treat doctors in the same way you would anybody else.
Is the outcome of the investigation shared with the individual's line manager, or is it confidential?
Well, it depends on whether they need to be. I mean, so not so much at the investigation stage unless they need to be. So once the investigation's finished, and if that leads to a requirement for more restrictions and so on, then I can see that you may have no choice but to share it with the line manager. But not necessarily at that point. I mean, whenever you make a decision about the practitioner that's going to have an impact on the way in which they're managed, then you're going to have to disclose that to the line manager, but not necessarily at the end of the investigation stage, potentially not even after a hearing, depending upon what the outcome is. Very much depends on how it impacts upon their practice and whether or not a line manager needs to know that. So very much need to know.
Our next person asks, could you talk about how the case investigator might engage with a specialist medical advisor? When might this happen? And how should their involvement be captured and included in the report?
Yeah, and that again, some really good questions. I will give you an example of the way that I managed it. I was undertaking an MHPS investigation myself as a non-clinician. I'm not a clinician at all, just a lawyer. And I had an issue that was raised in the MHPS investigation that involved good practice around record keeping. And I wanted to take specialist medical advice. So I went off and sought the advice of an independent medical practitioner, and it was very clear in the report that that's what I'd done, and I set out in full their advice to me as the investigator. So I think absolutely approach somebody. Sometimes it's possible, if you work with your HR team, to find somebody, or medical team to find somebody. Sometimes you do it independently, it doesn't really matter, but you would simply ask them the question. You may not need to, probably won't need to disclose huge amounts of detail. It depends on what you're seeking advice on. But ideally, you'd redact all of that. You'd get the advice from the clinical expert, and then reflect it in the report very openly and very cleanly, so that everybody knows where you've taken that advice from.
BMA rep challenged that their respondent had not agreed to the TOR prior to investigation starting. Not something that has happened before, and not something I thought was appropriate. Is it, though?
No, you don't have to agree the terms of reference, because if you think about what they are the organisation expressing what the concerns are in as much detail as they can. And if you sought to agree the terms of reference, of course, in many cases they're simply not going to agree. Simply not going to agree. So no, there's absolutely no requirement under MHPS to do that, and I don't think there's any general fairness point. I mean, of course, the individual is able to come back and comment on the terms of reference, and they frequently will. And there might be a case, I suppose, for making them clear to the individual first before you send them to the investigator, but certainly no requirement to do that. And it's not a negotiation, so it's not about trying to work out what's acceptable to the individual. It's about saying these are the concerns and this is what needs to be investigated. So I would not run it past the representative or the doctor before going out to investigation. No.
Do community interest companies have to implement MHPS?
No, I think is the answer to that. There's a group of organisations that were required to do that when it was originally set up. I'm not aware of any additional provisions that require that. Having said that, we do work with community interest companies who do have a form of MHPS and comply with it, because that's the nature of the way these things set up. But I don't think there's a formal requirement to do that, no.
Serious concerns relating to agency locums, how are these managed, please?
Yeah, another great question. I mean, you're not the employing organisation in those cases, and so you won't have a contract which incorporates MHPS from your perspective. So you're not required to do anything in terms of MHPS. But what generally happens is you report back to the agency, of course, in the normal way, and make it clear what those concerns are. So there's no MHPS element per se in those relationships, unless, and I think this is extraordinarily unlikely, unless there is a contractual obligation with the agency to the doctor to manage things under MHPS. There is a related point which I'll mention actually, which sometimes comes up, which is also in relation to locums, because we have this issue raised sometimes about locums. MHPS is a contractual thing in the sense that there is this national framework, but it only applies if it applies. In other words, it only applies if it's incorporated into contracts. And we have had a few contracts of locums which don't have any reference to MHPS at all. And, you know, very often their lawyers will come to us and say, you haven't complied with MHPS. And then we ask them why we should, because they're not actually incorporated into their contract. And usually at that point they go away, because you're not required to impose MHPS except in relation to those doctors that you employ.
Does the process timeline continue if the practitioner goes on sickness absence due to stress during an investigation?
It depends is the short answer, because it depends whether the stress prevents them from taking part in the investigation. And that might seem like an obvious point to make, but not being able to work because of stress is one thing. Not being able to take part in the investigation is quite a different thing. And so I wouldn't assume that the process would have to be paused at that point. And in fact, if the stress is associated with the investigation, you might find that occupational health encourage the doctor to take part in the investigation, try and resolve matters. So no, not necessarily paused. If the individual really, really can't take part and you've got medical evidence to support that, then you may have to have a temporary pause, but it doesn't necessarily follow.
How do probity issues link with MHPS?
Well, I mean, that's any issues about probity are conduct issues, it seems to me, and so they absolutely could be covered by an MHPS process if there's a concern about probity. Yeah, but it would have to reach the threshold of a serious concern, but they would be included, absolutely.
Next question, similar to attendance policy query, the use of trust disciplinary policy applies when no serious concern?
Yes. In short, if it's not a serious concern, you don't meet that threshold for MHPS, and so you deal with things in the normal way. Yeah, absolutely.
Is there any advice for a case manager? Often the case manager, when presenting the case, is faced with the practitioner's barrister as the representative, usually someone that has been called to the bar and specialised in medical law for many years. Although it's not a court of law, the atmosphere and the language use is very intimidating. There is no legal representative or support from the trust side, so very tough for case managers. Just wondering if there's any specific guidance available, or you just have to rely on our experience and steady nerve.
Really good question. Again, we're getting some great questions. I think there's a few points I'd make about that. The first is that if the doctor is bringing a barrister and legal representation, then a lot of trusts at that point will consider whether or not they have some form of legal support. And that usually takes one or both of these forms, either an advisor for the panel. And so I've been the advisor from an MHPS panel on many occasions where I'm there to provide support to them. And that helps because if the barrister is behaving in a way that is unnecessarily antagonistic, for example, or very legalistic, then having a legal advisor on the panel is helpful, because that legal advisor can support the chair to say, look, this isn't the way we're going to conduct it. I've done that job, as I say, many times, and I don't usually intervene, but I have intervened in a few cases where the legal representative, has been very aggressive towards witnesses, for example. So so that you can have that. So you can have an advisor at the panel. The other and/or is that you have a legal representative representing the trust side and representing the management side. And again, it's something I've done on a number of occasions. So that's the starting point. So there is an option for that to happen. Nothing under MHPS prevents that from happening, and that might be a sensible thing to consider. But if that isn't in place, so if the trust, the organisation has decided they're not going to have legal representation there, the only thing I would say from a case manager's point of view is to keep coming back to the point that this isn't a court process. This isn't something where there needs to be too much formality, and that you focus very much on the case in front of you rather than what might be sort of side issues. This may come as a shock to some of you, but lawyers sometimes focus on the less important and the side issues in a way to sort of intimidate a panel into making a decision. And so it's crucial for a case manager to keep coming back to, this is what the investigation found, these are the concerns, these are the allegations, this is what we're saying. But there's no easy way to deal with that. The final point I'd make is that very often in my experience, people are very intimidated and afraid by having a barrister or a legal practitioner rather on the other side from them. But like doctors and like every other profession, there are brilliant legal representatives, and there are terrible legal representatives. And we see that all the time. So it's not necessarily just because somebody has a qualification and experience doesn't mean they're going to be any good. And so it shouldn't necessarily be that intimidating. But those are just some tips, I think, for how to manage that kind of involvement. Yeah.
Is a doctor who is undergoing an MHPS investigation and who has restrictions in place obliged to inform other employers, for example, a private hospital where they may also practice?
Yes. There you go. That's an easy one. There is a requirement to do that. If there was a concern, I think I may have mentioned it earlier. If there's a concern from the employer that maybe that's happening without your knowledge, so you should know if they have private practice, of course. But if you don't know that and there is a concern, then that may be one of the areas where that's one of the reasons why you might go to the GMC early to make a referral to ensure that they are then informed. So yes, they are obliged to inform a private practice, but if you think that's not happening, there are ways you can make sure the GMC knows about it. Yeah.
What should a case investigator be commenting on in regard to professional misconduct with the CI report, and at what point of the investigation should this advice be attended?
So in terms of commenting on professional misconduct, I would expect a good case investigator to, as you suggest, take their advice, so make clear that they have taken advice because we think it might be professional misconduct, and then to set out clearly why you think that is something that was done in the exercise of medical skills. So I would expect that to be in the report. We have had cases where the case investigator hasn't picked up on the professional aspect to it and hasn't sought advice. That's not necessarily fatal, because the case manager can send it back and say, we think you should take advice at this point on the clinical aspects, and that's what the case investigator does. But I mean, other than to say we think it's professional misconduct at that point, if that's where you get to, I don't think the case investigator should go much further.
If the local attendance management policy refers to ill health capability, if termination should this be managed via MHPS?
Yeah, so if you've incorporated MHPS, which you would have done for the doctor, then there is that requirement to send it back to a capability process. So yes, in short, so you follow your ill health normal process up to the point of dismissal, and then technically you should send it back under the MHPS process for capability. Yeah.
The PPA are likely to be able to support with action plans for colleagues who are potentially unable to fulfil their contractual obligations due to ill health, but are not absent or sick. If so, at what point should PPA be engaged?
I think yes is the answer to that. I've not had one of those cases recently, but I think the answer is yes, because the support they offer is generally in relation to capability, and that whether that's driven by purely performance concerns or whether that's driven by ill health, I don't think it makes a difference. They are very willing to at least consider it. So I think when those concerns are there, I would go to PPA and see what they say. As I said to you before, PPA will come back if they think it's not going to be worth doing. So if they look at the issues and they say, we don't think we can help, they'll be very clear. So I don't think there's any harm at all in referring to PPA. Generally speaking, doctors are pretty happy for that to happen if they are struggling, if they're having difficulties, because the independent assessment can often help them.
Should the investigator be making recommendations in the investigation report?
MHPS is silent on that, so it doesn't actually say what you should or shouldn't do. My view and my advice usually is not to, because I think recommendations from a case investigator don't necessarily assist for the management of the case. And so as a general principle, I would say no, they shouldn't make recommendations. But that's not prevented by MHPS. And in some cases, you might decide you want the case investigator to make recommendations. The key thing is when you set out your terms of reference and when you have those initial instructions to an investigator, you make it clear what you expect. Because you don't want recommendations unless you've made that decision that you want them. But if you do want them, you need to be expressly saying, we want recommendations. So I wouldn't expect it, but in some cases you might decide as an organisation that it might be beneficial. But no, MHPS doesn't say anything about recommendations at all, so it's entirely up to you.
If a medic has applied for ill health retirement whilst on LTS absence, should the stage 3 final meeting go ahead, or should the trust await outcome of ill health application?
Well, again, MHPS doesn't say one way or the other, so we're looking at general principles of fairness. I think if the decision on the application for ill health retirement is likely to be fairly soon, as a general point of fairness, I think you're better to wait. In theory, you're not prevented, absolutely not prevented, but one of the things that comes out of the cases generally on ill health dismissals is that you are expected to have explored the possibility of ill health retirement. So in general terms, I would wait unless you think it's going to be far too long to wait. So depending on when the application was made, I would wait for the decision first. Otherwise, it's not so much an MHPS point, but there's a general fairness point.
There is a final question. Could you kindly clarify when and how MHPS will intersect with normal sickness process?
Yeah, so in order for MHPS to kick in, it has to be a serious concern. So if you don't think it's a serious concern at that point, in other words, sort of regular sickness absence, you manage it through your normal process. My advice is that you manage everything through your normal process up and until the dismissal stage, at which point MHPS requires you to go through the capability process. So start with your normal absence management process. You may end up in a capability process under MHPS if you get to that point. Thank you all.